Your Honor. I'm here this morning in the state of Ohio versus David Graves on two case numbers, the first being 24 CR 35 for a probation violation final hearing, the second being 25 CR 1342. On a prior day of court, the defendant did plead guilty to count 1, possession of cocaine, a felony of the 4th degree, and count 3, OVI, a misdemeanor of the 1st degree. Your Honor ordered a updated pre-sentence report on that case, which has been completed. We are here today for the purposes of sentencing.
He still hasn't pled to the PV, right? We need to do that first.
Correct, Your Honor. I think we just waived the probable cause. I don't think the
You're right.
final hearing's been officially waived.
We're going to address that first then. Case 24 CR 035, scheduled for a final hearing. Mr. Watts, what's the defendant's intention in that regard?
Thank you, Your Honor. May it please the court, after talking with my client, he is prepared to waive his final hearing and enter a plea of guilty to the violation, Your Honor.
Thank you. All right, Mr. Graves, in the first case, one that you've been on probation to the court for, you're charged with violating the conditions of your community control sanctions. Specifically, there's 3 alleged violations. The first is a Rule 1 violation, which requires you to obey all local, state, and federal laws, and it's alleged that on September 14th of this year, 2025, you were cited by the Whitcliffe Police Department for possession of a controlled substance, resisting arrest, open container, operating a vehicle that influenced of alcohol or drugs, and failure to control. That's the other case that we have before us. You're ultimately pled guilty to the possession of cocaine charge and an OVI. It's also alleged you violated Rule 8, which prohibits you from using, possessing, or having under your control any controlled substance not prescribed to you by a licensed physician. It's alleged that on that day, that other incident, September 14th, you were in possession of controlled substances, and you ultimately pled guilty to the charges for that. There's also a supplement or an addendum that was filed alleging another Rule 8 violation, again, which prohibits you from using any controlled substance, and it's alleged that a urine sample you submitted on September 16th after you were arrested tested positive for cocaine and marijuana. Now, you have the right to have a final hearing regarding these allegations, and that's a hearing where the state would be required to prove the merits of what they're alleging. Now, you could have this hearing, but you can also waive the hearing and plead guilty to the violation. Your lawyer has indicated he believes that's what you want to do, waive the final hearing and plead guilty. Is that correct?
Good morning. Yes, Your Honor.
Well, before I can accept your waiver of the hearing and your plea of guilty, I need to make sure you understand the potential consequences you face if you are found, in fact, to have violated the conditions of your community control sanctions. If, in fact, that did occur, the court could extend your probation up to 5 years. I can impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. If I did that, it could be 6 to 12 months in prison, and that could also be ordered to be served consecutive to any potential prison sentence that may get imposed for the new case, the other case that we are here for on sentencing. You understand the potential penalties you face if you're found to have violated your community control sanctions?
Yes, Your Honor.
Well, having been so advised, what do you want to do at this time? Do you want to have the final hearing, or do you want to waive that hearing and plead guilty to the violations?
Plead guilty, Your Honor.
Very well, then, as to the allegation that you violated Rule, let me get that up here. That you violated Rule 1 by having been convicted of a new criminal offenses. What is your plea to that?
Guilty, Your Honor.
As the Rule 8 violation for being in possession of controlled substance, what is your plea to that?
Guilty, Your Honor.
And as to the Rule 8 violation set forth in the addendum for testing positive for marijuana and cocaine, what is your plea to that?
Guilty, Your Honor.
All right, the court will accept your pleas of guilty, find that you did violate your community control sanctions in case 24 CR 035. We will now proceed to sentencing in that case as well as the sentencing in 25 CR 1342. We'll do both together. Any reason not to do that, Mr. Watson, or any reason not to proceed to sentencing in either of these cases?
No, Your Honor.
Then is there anything you'd like to say on behalf of your client in regards to both of these cases? Make your comments and obviously go for both cases.
Thank you, Your Honor. May it please the court. Yeah, I'm going to be brief. I know we had discussions in chambers. Mr. Graves, I believe, is a good person who's got a very serious problem. I know he's denied this problem to not only this court, to probation in the past. I think in discussions in chambers when probation brought up that it finally caught up to him, I actually thought that was very appropriate. I think it did. And unfortunately, how it caught up to him on this new case, the facts are obviously not good at all. He was behind the wheel of a vehicle, passed out. The vehicle was still in drive, on the road. And it took officers. They had to get into the car, put him in park. Took them a while to wake him up. Obviously, the cocaine was found as well. Your Honor, Mr. Graves has told me that he struggled with this for quite a long time. He knows this court previously gave him really 2 chances. They gave him a chance, and then I believe there was a probation violation on the old case already, and continued him on probation. So. And he was doing well there, I believe, for a while. Unfortunately, he fell off the wagon and hard. And Your Honor, we're here hand in hand. I know the court can do a lot today. Has a lot of discretion with regards to sentencing. I'm going to respectfully ask the court to consider a minimum sentence on both cases. Mr. Graves has expressed to me that he knows he's got some time ahead of him, but he plans on utilizing that time wisely. He wants to enter into some programs, do some AA. He wants to get out sober, and he wants to be sober. He doesn't want to be in this position ever again. He's expressed to me he's getting older. He's tired of this. He's tired of living his life like this, and I'm going to respectfully ask the court to take into account that he has accepted full responsibility here. He's very remorseful, and I'm hoping he'll get the help that he needs. Thank you, Your Honor.
Thank you. Mr. Graves, you have the right to address this court before you're sentenced in both of these cases. Is there anything you'd like to say in either or both cases at this time?
Yes, Your Honorable Judge Culotta, please accept this letter as I have written for mercy and regardless to my crime I have committed, in which I am truly apologize and must first explain that I am the reason I believe this is the root because of my actions and behaviors as a child growing up without a father figure were hard. Just to say that I'm sorry and I do have a problem and I'm sorry that I came in front of you and everything. I have my own business and everything. I'm trying to ask for the minimum on my fines, minimum on my license and driving privileges. And I apologize and I have a problem and I want to use this time, like you said, that you give me and everything to help better myself, and got 8 kids, 7 grandkids and all like that and everything, Your Honor. And just asking for plea for the mercy on the courts, Your Honor. I got a long letter. I ain't gonna take
Sorry?
up. I said I have a long letter. I ain't gonna try to read, take up a lot of time.
Well, you can say whatever you'd like to say. I'm not limiting you at all. It's up to you.
It's just above. And like I said, both my parents, they died of overdoses, and Mama was a prostitute. I was grown at 14, and I just made the wrong choices in life and all, and that's all. That's all, Your Honor. Just thank you for the mercy of the courts.
Thank you. Mr. Watson, anything else?
Nothing further, Your Honor.
Contract for the state of Ohio.
Thank you, Your Honor. The state is recommending prison on both of these cases. By my review of the pre-sentence report, the defendant has 8 prior misdemeanor cases, 7 prior felony cases. He was on probation at the time that he committed this new offense. The facts of that new offense are very serious. There is nothing that I see that would recommend him that he is amenable to community control sanctions, so we would ask for prison on both cases. Thank you.
Thank you. This court has reviewed the pre-sentence report investigation that was done in both cases, the original PSR done in the 24 case, as well as the updated PSR that was just completed. Also a drug and alcohol evaluation that was completed in this newer case. I've read and considered that. I've considered the facts and circumstances of both cases, the nature of the cases involved. I've considered everything that's been said here today. All of this is considered in light of the purposes and principles of felony sentencing set forth in 2929 11 of the revised code. As for the factors in 292912 in the older case, the 24 CR 035 case, I'm going to incorporate all the findings I made at the original sentencing hearing, first PV, with the additional finding at this time that the defendant has, again, failed to comply with the previously imposed sanctions ordered by this court, which is a factor indicating recidivism is more likely. In fact, one of the violations was for actually committing a new crime, so recidivism actually occurred. In regards to the 25 CR case, the court notes in regards to the seriousness factors, just the very nature of the offense itself makes this much more serious than normal. Quite frankly, it's only an F5 possession, I get it, but it's one of the worst ones I've seen. You're stopped at a red light, cars and drive, with your foot on the brake for a long time. There's one woman that pulled up behind you, sat through a whole cycle, then she left to go pick up somebody, came back and you were still there. People were beeping their horn, knocking on windows, reaching in your car, and you had no idea. And you're driving a car in that condition. Putting everybody in the community and everybody in that area at risk. You want to harm yourself by using drugs or drinking, whatever, but when you put the other people at risk, that makes it much more serious, and that's what happened here. And the officer in this case opened the door, put the vehicle in park, removed the key, you didn't wake up. Yelled at you, began tapping you on the shoulder, shining his flashlight in your face, you didn't wake up. Shaking you back and forth, yelling at you, you didn't wake up. And you're driving a car in this condition with people, other citizens around. Nothing makes it less serious. As for recidivism factors, in the new case, the court finds the defendant was on community control sanctions to this court at the time that he committed this offense. He has failed to comply with previously imposed sanctions ordered by the courts, including this court. In fact, he was on probation in this court. He had violated just in July. And despite his history, despite the fact that I gave him a break when I first put him on probation, I continued him again with the first PV. And within, a month after getting out of jail, maybe 2, he did this. He's got a significant criminal history. He's been to prison 4 times before already. He's not responded favorably again to previously imposed sanctions. A drug abuse problem that relates to the offense, and he's adamantly denied he has a problem. Even though he's got a history of drug problems, tested positive for drugs, has drugs on him, he points the finger at other people, denies he's got any issues. It's only today, for the first time, that we hear that he's got a problem. No factors make recidivism less likely. Under 292913B1, again, the defendant's previously served a prison term. Was on probation at the time he committed the offense. Prison is consistent with the purposes and principles of sentencing. The defendant's not amenable to available community control sanctions. For the life of me, I can't understand why you believe you're entitled to minimum sentence and mercy. You've been to prison 4 times. You're on probation when you did this. Why do you deserve mercy? Why do you deserve a minimum sentence? You don't. You're 49 years old, and you've been doing this your whole life. Wherefore, is the sentence of this court in case 24 CR 035. Defendant serve a term in prison of 9 months. He's given credit for 181 days he's already served. Case 25 CR 1342 is the sentence of the court. Defendant serve a term in prison on count 1 of 15 months. That will be served consecutive to the prison term imposed in 24 CR 035. Since it's consecutive, there's no credit on that case because he's getting all the credit on the first case. 181 days includes credit for both cases. Count 3, there's a sentence of 180 days. It's concurrent to the sentence in count 1. Impose the minimum fine of $565 on count 3 in the new case. Both cases, I'm going to suspend the defendant's driver's license for 3 years. That's a concurrent suspension, though. 3 years in each case, but concurrent. The court's going to order the defendant to pay all costs incurred in both cases. Need to advise you upon your release from prison. You could be placed on post-release control for up to 2 years. If you are and you violate any of those conditions, this is for both cases, the parole authority can return you to prison as punishment for violating the rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of the prison term imposed by this court. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. The court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, or transfer to transitional control. That's for both cases as well. 25 CR 1342, I'll order the forfeiture of the contraband and instrumentalities as part of the specification in count 1. I'll dismiss the balance of that indictment as well. Lastly, the court finds that consecutive service is necessary to protect the public from future crime and to punish the offender. This consecutive sentences are not disproportionate to the seriousness of his conduct and to the danger he poses to the public. And the court finds that he committed the offense in the 25 CR 1342 case while he was on community control sanctions to this court in 24 CR 035. I think that covers everything. Ms. Conter, is there anything else for the record that I...
Your Honor, for the license suspension, does that begin on the date of the offense or today?
What was, has his license been suspended? If there's no ALS, then it starts today. If there's an administrative license suspension, he'll get credit for that, but...
I would have to look, Your Honor.
It would start today, to my understanding.
Okay.
Unless it's been suspended. The fact that he hasn't driven, that doesn't get credit for that.
Okay.
Mr. Watson, anything else?
Nothing further, Your Honor.
Thank you.
All rise.
What?
Oh,
Well, All right, we are present in two cases, actually. 12 CR 010 and 15 CR 150. Both are captioned State of Ohio versus Timothy, is it Pache?
Yes, Your Honor.
That's correctly, Pache. In each of these cases, defendant filed an application to seal the record of arrests and convictions associated with each of those cases. Upon receiving that application, the court referred the defendant's matter to the probation department so they can prepare a report. That report has been completed. I've had the chance to review that. And we're here for the hearing on the request to seal. So, Mr. Levin?
Yes, sir.
Care to be heard on your request?
Yes, Your Honor. Thank you. Nice to see you.
See here.
Judge, Mr. Pache, as you know, was convicted in 2012 and 2015 for basically drug-related offenses. I'd like to show the court that he has rehabilitated himself in a significant way that contributes in an impactful way to his community. First of all, just in a personal sense, his wife, Kirsty, and their 9-week-old baby, Cash, are sitting outside the courtroom. Given the no baby policy, they're not in here right now, but I just wanted to let the court know that he is now married with a family that he is supporting. Secondly, he has, since his bouts with these felonies, become an extremely successful businessman. He launched a corporation called MVP Masonry Renovation. This is a construction company with a significant customer list, and I'd like to show the court the customer list as well as the total amount of revenue that's produced by that list. When did you start the company?
This is for this past year. It looks like that.
Just the last year.
20, when COVID hit, it was 2018, was it? 2020. Right when COVID hit.
What's the difference between all income and paid income?
Nothing. I didn't record that they paid me on the software. That's why it doesn't show on the right-hand side. There's different ones that I could show you. Nothing's different.
You got paid
Just
for all these jobs?
I'm sorry?
You got paid for all these jobs?
Yes, Your Honor. Yep. Yeah, I have tax information right here.
Yeah, I mean, I don't even see. I just see that. So you got a lot of work and then zero paid. I'm thinking.
Yeah. No, they were all paid actually. I even have stacks full of checks, including some from the city of Paynesville. On here, I did about $80,000 worth of work for them last year as well for Michelle LaLumpa, head of Parks and Recreation.
How do you get your work? What do you do?
Just by word of mouth, and they call me. I've never paid for a lead ever.
You've never paid for what?
Paid for a lead, like those companies for leads. I've never, ever, I don't even know how to do it. I wouldn't have known how to start. Everything is word of mouth and just my phone ringing.
So what do you do with your business?
I do masonry restoration, so I rehab bridges. We do a lot of stuff with swing stages, which is like height stuff. Like I just did a $169,000 job for Signature Health in Ashtabula, where we hung a big 40-foot swing stage on the side of their 10-story building out there, and the whole facade was falling off, so we had to go up there. We had to pin the facade underneath of it with steel helifix rods, and then we had to open up the whole wall above it where it was actually like 3 feet away from the top so that nobody can get hurt underneath. Set up, stuff underneath for fall protection for pedestrians, stuff like that first, but we do a lot of stuff like the window washers basically do on high-rise buildings.
How'd you learn to do all this?
Actually, after I got released from treatment and stuff, after I got out, I went and worked for a company called Frost Building Maintenance, and I was actually hired on as a carpenter, and during my time there, I noticed he handed me a invoice one time, and I saw what he was charging for the brick repairs, and I was like, whew. So I started paying attention.
Compared to what he was paying you?
I started paying attention, and the money is in restoration is where the money's at as far as masonry goes. But however, I started paying attention, taught myself, and then it's funny. I'm good friends with Frost still today, even though I quit on him. He's a very good guy to know. He teaches for architectural preservation actually at a campus downtown and stuff. He's a good contact to know, so I'm glad he ain't mad at me still. But he actually gave me a $5 raise, and he told me he never gave anybody a $5 raise before, and I quit on him next week because I got approached by a union representative, and I ended up joining the union. I went into the union for a year, and then when COVID hit, my boss he used to bank our hours for us, which means if we wanted to come in and work on a Saturday, he would take those hours and put them in a little notebook or whatever, and then if we got rain day or something during the week, we'd pull them out and, we still have a 40-hour check basically. Well, when COVID hit, he took out a small business loan, and I remember it was the first week that unemployment was giving out the $1,200 or whatever it was for COVID or all that stuff, the extra money, and I only worked 6 hours that week. So I called in my hours to Job and Family Services and told them I worked 6 hours. Well, they called me and they said, well, you got a 40-hour check called in from your boss. I called my boss. I'm like, what is going on? Oh, well, we had to use some your banked hours because I'm getting audited. I'm like, no, you're not. I'm like, you had to use your hours because you have to use the money before you can use the loan up, or else you got to pay it back. I'm like, I'm not a retard. I quit on him that day, went and bought a brand new vehicle, showed up at his shop the next day, started my own company. And
How long ago was that?
That was as soon as COVID hit, right when COVID hit, 2020. So
you've had this business for 5 years now, a little over 5 years?
Yep. Yeah, I employ 8 people, and
How old are you now?
I need about 15 more.
How old are you now?
I'm sorry? 42.
How old are you now?
I'm 42. Yeah. But I also give a chance to people that have, got in trouble in their lifetime. Pat Gallagher refers people to my company all the time. I actually got 2 guys that I kept from him, as well as Salvation Army. Some of them I keep, some of them, work out for a season, but I've kept a couple of people that are my permanent guys now, actually, from doing that.
Mr. Levin, you may continue.
Thank you, Judge.
You can be seated, Mr. Pichet.
Pichet took some of my better lines, so I'll have to improvise now. As indicated, just some of his work includes not only bridges, high-rises, the Kirtland Public Library, the Wycliffe Public Library, Signature Health, Fenn Tower at Cleveland State, the City of Painesville Courthouse right down the street, and Cleveland City Hall. I have with me some, you have your glasses on, you might be able to see some of these. These are just photographs of some of his work, and there's in there,
I really can't see.
yeah, I had trouble with that myself.
Okay.
Your Honor, I also have some letters of support. One's from Joshua Arnold, a longtime friend of his who runs the Apex Paper Box Company, Garrett Gray, sales manager from National General, which is part of Allstate Insurance, Bill Hanchowski from Willow Grove, an apartment complex in Willoughby, where he has done some expensive work. One of his employees wrote a letter saying what a good boss he is, and also I have a letter from his wife, who fortunately wrote something good about him. Here's some of the other photographs. The shape that he has is also lights up his home in Eastlake, so it's sort of a neighborhood destination for people during the Halloween and Christmas holidays. It's hard to make out those photographs, admittedly, but they're there.
I'm already seeing my 45-foot Santa that's been going viral. Everybody's posting lately.
I could see that in the picture.
And here are the letters of recommendation.
I know.
All right, go ahead, Mr. Levine.
Thank you, Your Honor. I'd also like the court to know that since 2015, Mr. Bechet has been sober. And I think that's just important news, also indicating his rehabilitation. He tells me that there are some larger jobs that he has been rejected from because of his criminal record. And if this were granted, it would have a significant boost to his company, allowing him to hire more people and to be even more of a contributor to this community. And I believe that he has a great deal to benefit by having these matters sealed, and that the state really has very little interest in keeping them unsealed. He has nothing pending right now, Your Honor, no prosecutions.
No.
Thank you, Your Honor.
Well, let's talk about that. That's my biggest issue. You said you haven't used, you've been sober since 15. What's with these recent cases?
So,
That doesn't make any sense if you're not using, quite frankly.
yeah, trust me, I know. So, I had a situation where I was at, when I stopped for, I had my friend Douglas Miller employed, and I gave him a chance, and that was the wrong mistake. I was with him at Menards, stopped on my way to a job site actually. He was supposed to go grab a sink, and he decided to stick something, I think it was like literally like a $20 pair of lights this dude stuck into a sink box. And I paid for everything technically. We walk out, cops are waiting for us at the door, and he literally just took off in beelines and got chased and tackled by police, and I didn't even know what the heck was going on. And yeah. That day, Your Honor, I did not bail him out, and because I had, I don't know.
Yeah, but you didn't. How you described it, you didn't commit a crime.
No, I didn't say I didn't commit a crime.
Well, you pled guilty to one.
Well, yeah. Well, so when I went to the court with my record, I couldn't chance going to jail, and I was told by the counsel that I should, plead not guilty and go and talk to him about the deal, and you know as well as I do, with a record like mine, they looking at me like, yeah, okay, you're probably full of it, even though I'm running my own business, everything. So that, they told me, was the best way to take care of it without making sure I wouldn't lose my company, basically. So 2021 was me.
And that was in Parma, or Brooklyn Police, with Parma Municipal Court.
Wait, what?
There was one in Mayfield Heights in 2020. That you didn't go to court until 22. And then there was something with the Brooklyn Police Department in 21 through the Parma Municipal Court.
Yeah, that's the Menards one, the Parma one.
All right, then what happened in Menor Municipal Court just this year?
Yeah, Menor Municipal Court was all my doing. So I literally went there to go pick up a Sonos port or a.
You went where?
Best Buy. I went to Best Buy, Your Honor, to go pick up a. I have a Sonos amplifier or port. That's what it's called. And I was messaging Sonos supports on their site, and they told me they needed to know which one I had. Yada yada. I told them, I was like, I just bought it from Best Buy. Like, well, we need to know the number on the box. Blah blah. Okay, fine. So I went up there because I was buying an amplifier anyways from them, and it was $700 or something for the Sonos amp or whatever that I was purchasing. And when I ripped the corner of the sticker off of the one box because I needed the number on it, and I literally didn't have a phone, and they scanned the wrong barcode when I went up to the register, and it was like an $83 difference. Like literally, the one was 700 and something, and the other one was 600 and something, or 500 and something, and they literally charged me like I was trying to swap a price tag and deceive them, and that's not what I was doing at all. Not by any means necessary. I had plenty of money, and I had no reason to rip them off of anything. But that was still my fault. 100%. I should not have, put the sticker on there. But that's what happened. I mean, not a lie. I don't need to steal. I make plenty of money. I'm very proud of that. I don't live that type of life anymore where I need to steal or, do drugs and live day to day by, that. I bought a house in 2018. I've renovated the whole entire completely house from top to bottom since then. I mean, all I do is work. My wife doesn't even see me sometimes. I mean, doing paperwork and everything else after the jobs. I'm on every single job site that I run. I have a couple foremans, but I'm on every job. And doing paperwork and all that at the office afterwards, I literally, that's all I do is work.
Is there anything else you'd like to say in regard to support of your application?
Just that I would appreciate the, getting it sealed. It would mean bigger opportunities for me and, lessons for my son not to be able to know stuff like that. And I mean, I would greatly appreciate it, but that's all, Your Honor.
Thank you. Mr. Levin, anything else on behalf of the request?
No, Your Honor, thank you.
On behalf of the state of Ohio, Ms. Linden?
Thank you, Your Honor. Your Honor, in my response, a couple of things that I pointed out was, maybe it's the misfortune of Mr. Pesce, but he was probably the first case that I had when I started working with our office. So I've known him since back in 1995. I know that he had at least 27 cases while he was there, and that behavior has continued, and he's had now additional cases from 2020 to 2025. So in terms of looking at that and looking at the time frame, looking at the fact that the same behaviors have continued from 1995 till present, that's why the state has concerns. Certainly things that he's done to better himself, that's wonderful that he's been able to do that. However, the state's interest in maintaining this based on his long history and continued history, I think is important for anybody in the future who is going to employ him to understand that these are issues and these continue to be issues for him. Had he not had anything since 2020, maybe the response would be a little different, but he's continued the same route, the same road that he's had since I first came in contact with him. And so based on our response and based on his continued history, we do not believe that it is appropriate to seal his record at this time.
All right, I'm going to take the matter under advisement and issue my ruling. I'll issue it this week, so you'll receive.
Your Honor, may I just be here?
Sure, I'm sorry.
So briefly. Thank you. I have great respect for Taylor Linden. She and I were involved in a very complex criminal matter. She's an excellent lawyer for the Lake County, and but I have to submit that in her brief, bringing up matters that took place when he was 15 is really a stretch. I have had hundreds of expungement hearings with this nonprofit I work with called Legal Works. Frequently, it's brought up that somebody has.
Now, let me stop you right now. I'm not considering his juvenile history. You can say whatever you want, but that's not going to come into play here.
No new felonies, no other drug cases.
The biggest issue is just theft earlier this year or last year. But
that's true. These are 3 wrinkles. I wish they weren't there. He explained that they were each a unique situation, causing him some difficulty.
I'm not saying that's preventing this from happening. But I'm just saying that's the biggest concern.
I understand.
Juvenile history, I'm not considering that at all.
Other than these 3 wrinkles, he has a clean record, an exemplary member of the community, contributing much, hiring people, working with the court in Euclid, working with the Salvation Army. I think he's really a model citizen, but for these other incidents. Thank you, Judge.
All right, I'm going to take it under advisement, but I'll get a decision issued here very shortly.
Thank you.
Thank you, Your Honor.
All right.
We're here today in the state of Ohio versus Davion Irvin, case number 25CR1273. The defendant is present counsel Rachel Smith. We're set today for an intervention in lieu hearing. It's the state's understanding the defendant is going to withdraw his previously entered plea of not guilty and enter a guilty plea to count 1, grand theft of a motor vehicle, a felony of the 4th degree, count 2, receiving stolen property, a felony of the 4th degree, count 4, criminal damaging or endangering, a misdemeanor of the 2nd degree, and count 3, I think I got one out of order there, also criminal damaging and endangering, a misdemeanor of the 2nd degree. The state would then ask to dismiss count 5, a misdemeanor. The defendant has 255 days of jail time credit, and that intervention in lieu motion was filed by defense, and those reports have been completed. Thank you.
Thank you. Ms. Smith, care to be heard on your motion?
Thank you, Your Honor. This is a motion for intervention in lieu. As the court's aware, Mr. Irvin is a young man that does not have a significant criminal history, although he has had some struggles over the years. However, it's Mr. Irvin submits for this court that the event in his life that brought him before this court and led to him making the series of decisions that he did prior to the instant offense, it was the death of his sister. Mr. Irvin does come from a closely knit family. His sister died unexpectedly in the spring of 2024, and Mr. Irvin has shared a number of struggles that followed the death of his sister. He regrets making the choice to cope with that loss by using drugs, and as a result of the coping mechanisms that he chose, he found himself in the midst of a pretty severe mental health crisis as well as a drug episode. Mr. Irvin was referred for competency early on in these proceedings, in fact the proceedings in front of the municipal courts. He was sent to North Coast for restoration and returned back to Lake County in August of this year. Mr. Irvin has great regret for his conduct and has a strong support system. He's also established himself with Signature Health and is receiving treatment there. He would ask the court to grant his motion for intervention in lieu so that he could have additional assessments done through Signature Health and complete any treatment that the court may feel is warranted. But Mr. Irvin does believe if he is given the mental health treatment and the substance treatment here in this court that it will help to change the trajectory of his life, and he realized that the burden is on him to make sure that that gets done.
Thank you. Mr. Irvin, I'm sure your lawyers explained to you what intervention in lieu of conviction is all about, but I'm going to do the same. What it is, it's a request that's made alleging that a criminal offense was committed because somebody was either drug dependent and or due to a mental illness. And in your case, it's alleged that both of those played a role in this. And the significance of it is that if I grant your motion, you're going to have to plead guilty to the charges, but then any finding of guilt is postponed, it's put off, as well as any sentencing, and ultimately any conviction of the offense. You're then put under a period of supervision with the probation department with a plan that's put in place to try to help you get back on track. If you successfully complete that plan, all the charges get dismissed. They're not in your record, which is a big deal, especially this day and age with not having any felony convictions on your record. I know there's some misdemeanors there, but no felonies, and those would remain off. So obviously it's a big deal and pretty extraordinary request, quite frankly. I guess I'll let you be heard on your request. Is there anything you want to say in regards to why you think the court should consider this and do this?
One more time, sorry.
Is there anything you'd like to say? You don't have to. Is there anything you'd like to say as in regards to why you would like this to be granted, why you think you're a good candidate for this?
Yes, Your Honor, because I never really knew that death could go the way it went, and I didn't really know that the way that I was going to cope with it, aka using ecstasy and using drugs, was going to put me in a mental state where I really wouldn't know my outcome. Ever since March 9th, it has been a downhill spiral for me. I want to be able to provide for my family, provide for my mother, and be there for her. And me putting myself in this situation, I clearly cannot do that, so I regret a lot of things that I have done. But honestly, I'm trying
So in order for me, I'm sorry.
Honestly, I'm trying to get help, and I'm willing to get the help I need, and I'm looking for help.
So in order for me to find that you're eligible for this and to grant it, I need to find several factors, and all of them weigh in your favor, except for one. I'm not saying the one doesn't, but there's one I'm struggling with, and that is that you are able and willing and amenable to follow all the conditions of the intervention plan that would be put in place, the rules of probation. And I say that because you spend so much time in custody. You're in jail, you're in the hospital, your lawyer goes to an arraignment and gets the judge to reduce the bond, you get you out, and then while you're on bond, you're using drugs. And even that was after you went to probation department. You went to the probation department. Wait, am I wrong about that?
You're correct, Your Honor. He provided a clean screen to probation. It was the first time, the second time
Yeah, right, okay.
It was positive for marijuana.
So it was after you showed up to probation, you decide when this is pending, and you know you're there to get a report put together for the court to consider in regards to granting you this, what I consider to be an extraordinary request, and you decide to use drugs. It blows my mind, quite frankly. What was going on there with that decision?
I take accountability for my actions, and
I'm not asking about that. Why? Why would you do that?
I ran out of medicine, and I was just grieving my sister, and I know that's not an excuse to try to put out there, but I was in the midst of getting my meds, and I just had an opportunity to smoke, so that's what I did.
And that opportunity you took advantage of, if that's the right word, put you back in jail now. You're in jail during the holidays. You're not going to be able to do that if you get put on this program. You understand that?
Yes, sir.
And there's not going to be excuses. I mean, I appreciate the fact that you're struggling, perhaps with, not perhaps, that you are struggling, and we're going to try to put stuff in place to help you with that. But that's not going to be an excuse to violate probation or to start using or do anything like that. You understand that?
Yes, sir.
And with treatment in lieu of convictions, there's no second chances. If you violate, you lose the treatment in lieu. That doesn't necessarily mean you go to prison. We'll then go to sentencing, and I'll consider the case like I normally would for any sentencing case. But you're going to lose that opportunity for intervention in lieu of conviction. You only get one chance at that. You understand that?
Yes, sir.
You going to be able to follow the rules?
Yes, sir.
All right, I will find the defendant is eligible for intervention in lieu of conviction, and it will be my intention to grant that motion at the appropriate time. But before that, you need to plead guilty to the charges. And if I accept your plea, your motion will be granted. So before I can accept your guilty plea, I need to make sure you understand what this is all about. I need to make sure you understand what your rights are that you have that you give up by pleading guilty, the rights the penalties you face. You make sure you understand what it is you're actually pleading guilty to. So for me to determine all those issues, I'll ask you a series of questions. If at any point when I'm asking you these questions, if you're unsure, unclear of anything I'm asking you, if you need anything repeated or clarified, if you want a moment to speak with your lawyer to ask her questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right?
Yes, sir.
All right, let's get started then. How old are you, sir?
23 years old, sir.
23?
Yes, sir.
Are you able to read and write the English language?
Yes, sir.
Do you have any difficulty with that, or difficulty understanding what you read in English language?
I tend to reread sentences a couple of times, but after a minute, I get the hang of it.
Okay. Well, the only reason I ask that is that there's going to come a point in time when you have to go through some paperwork. I know you maybe already did that, but can you assure me that you will, or you did ask for help if you were having any difficulty reading it, first of all, or understanding what you read? You'll do that?
Yes, sir.
All right. Are you a U.S. citizen?
Yes, sir.
Now, before you came into court today, have you had any drugs or alcohol of any kind?
No, sir.
What about in the last 48 hours?
No, sir.
What about prescribed medication?
My prescribed medication is at home, sir. In the jail, you have to come in with freshly refilled medicine. So my meds are sitting at home.
So you haven't been taking anything?
Since I've been in jail, no, sir.
Are they putting you on anything there? What is your medication?
Abilify and Zoloft, I believe.
Okay. We'll get you on that. You have the medication at home?
Yes, sir.
So it needs to be brought up, or?
I was taking it while I was at home. The last time I got into a situation in the jail where my mother brought in medicine, it wasn't given to me because it wasn't freshly refilled from the pharmacist.
So what medication do you have at home? Hasn't been freshly refilled, I'm assuming?
It's not. I was taking it until I came to jail.
That's the medications you're taking, Abilify and Zoloft?
Yes, sir.
Right. So you haven't had any drugs or alcohol prescribed, illegal, anything within the last 48 hours?
One more time?
You haven't had any type of drugs, alcohol, medication, anything within 48 hours?
No, sir.
All right. Now, did you receive a copy of this indictment in this case, the document that sets forth the charges you're accused of committing?
Yes, sir.
Had a chance to look that over?
Yes, sir.
Now, the indictment, there's 5 counts, you're pleading guilty to 4 of them. I'm going to go over those with you. If you have any questions, make sure you ask. But in count 1, what's alleged here and what you're admitting to is on or about January 8, 2025 in Lake County, Ohio, that you did with purpose to deprive Damian Stanzak, or David Stanzak, the owner of certain property, being a 2006 Dodge R15 motor vehicle. You knowingly obtained or exerted control over that property without the consent of the owner or anyone else authorized to give consent. Again, the property involved is a motor vehicle as defined under our code, which makes the offense grand theft of a motor vehicle a felony of the 4th degree. Do you understand what you're charged with and pleading guilty to in count 1?
Yes, sir.
Any questions about it for me?
No, sir.
Now, count 2, what's alleged is on or about that same day, January 8, 2025 in Lake County, Ohio, that you did receive, retain, or dispose of certain property, being a 2024 Volkswagen, the property of another person, name of Diasha and or Ulysses Cage, and that you knew or had reasonable cause to believe that that Volkswagen had been obtained through the commission of a theft offense. The property involved, again, is a motor vehicle, which makes the offense receiving stolen property a felony of the 4th degree. Do you understand what you're charged with and pleading guilty to in regards to count 2?
Yes, sir.
Any questions about that?
No, sir.
Now, in counts 3 and 4, you're charged with criminal damaging or endangering. And what's alleged in each of these cases is that on or about January 8, 2025 in Lake County, Ohio, that you did knowingly by any means cause or create a substantial risk of physical harm. And in count 1, that's to a 2022 Mitsubishi motor vehicle which belonged to Alicia Hill, and you did that without her consent. And as for count 4, the property involved is a 2019 Dodge belonging to Robert Cease, S-E-E-S-E, and you did that without his consent. So that conduct in each of those 2 counts constitutes the offense of criminal damaging or endangering, and they're each misdemeanors of the 2nd degree. Do you understand what you're charged with and pleading guilty to in counts 3 and 4?
Yes, sir.
Any questions about that?
No, sir.
Now, there is one further count, count 5, that's being dismissed pursuant to the agreement. Is that your understanding?
Yes, sir.
Do you have any questions about that?
No, sir.
Well, then before I can accept your guilty plea to the first 4 counts I just read to you, I need to make sure you understand all the rights you're giving up. And you, first of all, have a right to have a trial. And a trial could be to me as a judge, where I listen to all the evidence and I make the decision whether you're guilty or not guilty. But you also have a constitutional right to have a jury trial. And a jury trial would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. The jurors would consider and weigh all that evidence, and then those jurors would make that ultimate decision. And that ultimate decision reached by those 12 jurors would have to be a unanimous decision. Unanimous means all 12 of them would have to agree, one way or the other, whether you're guilty or not guilty. Do you understand that?
Yes, sir.
Do you understand by pleading guilty you're giving up your right to have a trial?
Yes, sir.
Now, if we had a trial, the prosecutor here would represent the state of Ohio. And she would have what we refer to as the burden of proof. Having the burden of proof means it's her job, or she bears the responsibility or the obligation of proving you guilty before you could ever be found guilty. You're presumed innocent of all these charges, and that presumption of innocence sticks with you and stays with you until the state, if at all, was ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes, sir.
Do you understand by pleading guilty you're giving up your right? Well, strike that. I jumped ahead of myself. When I talk about the burden of proof, since it's a criminal case, that burden is called proof beyond a reasonable doubt. That's the highest burden there is in our justice system. What it actually means, it's the amount of the evidence and the quality of that evidence the state would have to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of the charges beyond any reasonable doubt before you can ever be found guilty. Do you understand that?
Yes, sir.
And you understand you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt?
Yes, sir.
Now, to do that, or at least try to do that, if we had a trial, the prosecutor would bring witnesses that come to court to testify for the state by answering questions from the prosecutor. Once those witnesses answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same persons questions, and that's called cross-examination. She could ask them anything she wanted to within certain rules. Do you understand that?
Yes.
Do you understand by pleading guilty you're giving up your right to cross-examine or confront those witnesses that would come in here and testify against you?
Yes, sir.
Now, you'd also have the right at a trial. You can call your own witnesses to come to the courtroom and testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that. You're not required to do that, but you have a right to do that if you want to. Do you understand that?
Yes, sir.
And you further can request this court issue an order. We call that order a subpoena. What a subpoena would do is it would force or make someone come into court and testify for you and answer your lawyer's questions if they were not willing to come in voluntarily on their own. Do you understand that?
Yes, sir.
Do you realize you're giving up that right?
Yes, sir.
Now, you'd also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That's a decision or a choice that you would have to make. Do you understand that?
Yes, sir.
And since that's your choice, what that really means then is that nobody else could force you or make you, nobody could compel you to testify against yourself at a trial. And if you didn't want to, I can't make you testify. But most importantly, the prosecutor here is not allowed to call you as a witness and make you get up on the stand and answer questions and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes, sir.
You further understand that if we went to trial and you were found guilty, you would have the right to appeal or challenge that guilty finding to another court, a court that sits above me and reviews my decisions. By pleading guilty here today, now you're not being found guilty, and I've explained that already, but you're giving up any right you have to appeal any issues that you could have raised up until this point. And if you are ultimately found guilty because you violate the plan, and we're hoping that doesn't happen, but you'd be giving up your right to appeal that guilty finding. Do you understand that?
Yes, sir.
All right. Well, do you understand all these rights I've just explained to you?
Yes,
These
sir.
are all the rights you have and all the rights you're giving up by pleading guilty. Understand them all?
Yes, sir.
Still want to plead guilty?
Yes, sir.
Now, your guilty plea is a complete admission of guilt, so it means you're admitting to the facts being alleged by the prosecutor. We're not going to argue that you didn't do it or it's someone else's fault or anything like that. Do you understand that?
Yes, sir.
Further, as a result of pleading guilty, the effect of a guilty plea normally is that you're found guilty and you're sentenced. Now, again, that's not going to happen here. What will happen is if I accept your plea, I will stay or postpone any further criminal proceedings, including finding you guilty and sentencing. I'll put you under a period of supervision with the probation department. We'll put a plan together for conditions for you to follow. And if you do that successfully, the case gets dismissed. If you don't, we'll come back here in court, and after a hearing, you'll be entitled to have a hearing if there's some allegation that you didn't comply with the conditions. If after a hearing I found that you didn't, what would happen at that point then is I would lift or vacate the postponement of the sentencing. I'd find you guilty of the charges and we proceed to sentencing. So again, we're hoping that doesn't happen, but in case it does, I need to make sure you understand what all those potential penalties could be so that you're making an intelligent decision here when it comes to pleading guilty, all right?
Yes, sir.
So I'm going to review those with you at this point. And in that regard, in counts 1 and 2, you're pleading guilty to felonies of the 4th degree. Each of those are punishable by a possible term in prison of a minimum of 6 months, a maximum of 18 months, or any whole number in that range of 6 to 18. Do you understand that?
Yes, sir.
Now, criminal damaging, the charges in counts 3 and 4 are each misdemeanors of the second degree. Those are punishable by possible terms in the Lake County Jail of up to 90 days each. Do you understand that?
Yes, sir.
Now, in regards to the 2 felonies in counts 1 and 2, if a prison term is imposed on those 2 counts, any jail sentence imposed for the criminal damaging by law has to be served concurrent with any prison term, which means at the same time. I can't run them consecutive. Do you understand that?
Yes, sir.
However, in regards to the 2 felonies in counts 1 and 2, if I impose a prison sentence at any point, I can run those 2 prison terms consecutive to each other. Again, consecutive means one after the other. You'd serve the prison term in count 1, finish it, then the prison term in count 2 if they are consecutive. Do you understand that?
Yes, sir.
Now, I don't have to do that. I can run them concurrent if I wanted, which means at the same time. But I need to make sure you understand the maximum penalty you could face. And if I gave you the maximum sentence on each count and ran them consecutive, you'd be looking at a maximum possible prison sentence if we ever came back here for sentencing of 3 years in prison. You understand that?
Yes, sir.
And that also could be consecutive to any of the other, if you were to pick up a new case. I'm not saying that's going to happen, but if you were and you were to be sentenced for that, it could be consecutive to that as well. Do you understand that?
Yes, sir.
All right. Now, I believe I know the answer to this, but do you have any other charges pending against you right now?
No, sir.
I understand that you were on probation when this happened, but that's terminated, right? Your probation is no longer, it's over?
Yes, sir.
So you're not on probation anywhere else right now?
No, sir.
Now, if a prison sentence ever was imposed, upon your release from prison, you could be put on what's called post-release control. It's sometimes called parole. It's a period of supervision you would be on after you served and completed the prison sentence. And in this particular case, it could be up to 2 years. Do you understand that?
Yes, sir.
If you ever violated any of the conditions of your post-release control, the parole authority could send you back to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half whatever the prison term is imposed by the court. Do you understand that?
Yes, sir.
Now, aside from the possible prison sentence, there's other sanctions that could be imposed. Some I will. You will be ordered to pay court costs or reimburse the county for any cost of confinement, community supervision, or treatment, if any that were applicable. Do you understand that?
Yes, sir.
You could be fined, if we proceed to sentencing, you could be fined up to $5,000 in the 2 felony charges, as well as $750 in the 2 misdemeanor charges. So altogether, that's a possible fine of, $11,500 that you could be ordered to pay. Do you understand that?
Yes, sir.
You will be ordered to make restitution to any victim for an economic loss that's any victim suffered. And in this particular case, one of the victims of the criminal damaging suffered economic damages in the amount of $256.31. So you will be ordered to pay that as a part of an intervention plan. Do you understand that?
Yes, sir.
Now, a few moments ago, I explained what the possible prison terms could be if I imposed a prison sentence. I did use the word possible because prison wouldn't be mandatory if I sent you to prison. You would be eligible for probation at that point. I would obviously look at all the information I have. I'd consider why we're back here to begin with, what was the violation that led us back here. But I'd make the decision at that point whether to put you on probation or not. It's not automatic just because you're eligible. I'd look at everything before I made that decision. You understand that?
Yes, sir.
Now, if you were put on probation, it could be for up to 5 years, and as judge, I'd have the discretion to order a wide variety of rules and conditions for you to follow, which could include an order that you serve time in the Lake County Jail. Do you understand that?
Yes, sir.
Lastly, if you are on probation and you're violating any of the conditions of your probation, we would have a hearing to see if you're what's called a probation violator. If it was determined that you were, I could extend your probation, could impose more restrictive sanctions, including jail time, or I could end your probation and send you to prison at that point. And again, it could be up to 3 years in prison altogether, which could be consecutive to any other new case if there was a new case. Do you understand that?
Yes, sir.
All right, well, do you have any questions at all regarding the potential penalties you face by pleading guilty if we ever had to proceed to the sentencing hearing?
No, sir.
You understand all the possible consequences that could occur?
Yes, sir.
Any questions for me?
No, sir.
Do you still want to go forward and plead guilty?
Yes, sir.
Have you had enough time to discuss this with Ms. Smith? Have her go over everything with you and answer all your questions?
Yes, sir.
Are you satisfied with her advice and counsel?
Yes, sir.
Have you been threatened or coerced in any way to plead guilty to these
No, sir.
charges?
No, sir.
So you're entering your guilty pleas freely and voluntarily?
Yes, sir.
All right then, Mr. Irvin, any questions for me at this point regarding anything we've just talked about? The rights you're giving up, the penalties you face, what you're pleading guilty to? Any questions?
No, sir.
Do you need any more time to speak with your lawyer?
No, sir.
All right, then what's going to happen at this point, prosecutor here is going to advise the court as to what she believes the evidence would show if we had a trial regarding these incidents. I want you to listen to her because I'll have some questions for you about that then, all right?
Okay.
All right, let's go.
Thank you, Your Honor. Had this matter proceeded to trial, the state would have proven beyond a reasonable doubt that on January 8th, 2025, Davion Irvin was driving a 2024 Volkswagen motor vehicle belonging to Dasha Cage. He drove that vehicle from Cuyahoga County into Lake County up to the Parr Lane and Pine Ridge apartment area, which is, Parr Lane is in Willoughby Hills, Pine Ridge is in Willoughby, nonetheless, that is Lake County, Ohio. And the defendant did know that that vehicle was obtained by the commission of a theft offense. While up at that apartment complex, the defendant then broke a window on a 2022 Mitsubishi belonging to Alicia Hill, and also broke a window on a 2019 Dodge belonging to Robert Cease. Finally, the defendant got into Damian Stanik's 2016 Dodge R15 truck and drove that from the Parr Lane apartment area without that owner's consent. And that is a motor vehicle. Thank you.
Thank you. So were you able to hear what the prosecutor just had to say regarding what the facts would be in this case regarding
Yes,
these
sir.
incidents?
Yes, sir, I did.
What, if anything, do you have to say about any of those facts? Are they true? Did you do what she said?
Yes, Your Honor.
Very well, then. Regarding count 1, charging with grand theft of a motor vehicle, felony in the 4th degree, what is your plea to that count?
Guilty, Your Honor.
Regarding count 2, charging with receiving stolen property with the property being a motor vehicle, felony in the 4th degree, what is your plea to that count?
Guilty, Your Honor.
And regarding counts 3 and 4, charging with criminal damaging, each misdemeanors of the 2nd degree, what is your plea to those 2 counts?
Guilty, Your Honor.
All right, I have in my possession here a 4-page document called a written plea of guilty and judgment entry, which explains everything I've just gone over with you. Before I can accept your guilty plea, I need to make sure you understand what this document says and that you sign it here in open court. Now, my understanding is before I came out here, you had a chance to review this document with your lawyer. This is the paperwork I was talking about earlier. Is that true? Did you have a chance to do that?
Yes, sir.
Did you have any difficulty reading it or understanding what you were reading?
No, Your Honor.
Did she review it with you, though?
Yes, Your Honor.
Ms. Smith, is that correct? Did you go over this with Mr. Irvin?
That is correct, Your Honor. I answered his questions and he indicated an understanding of the document.
Is that correct, Mr. Irvin?
Yes, Your Honor.
Any questions for me about it?
No, Your Honor.
It also appears you signed it. Did you sign it?
Yes.
And you witnessed that, Ms. Smith?
I did, Your Honor, and I signed it as well.
And you as well, Ms. Bell?
I did, Your Honor.
Very well, then. At this time, the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in open court. His lawyer advised of all his constitutional rights and made a knowing, intelligent, and voluntary waiver of those rights. The court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea of guilty to count 1, grand theft of a motor vehicle, felony to 4th degree in violation of 2913.02A1. Count 2, receiving stolen property, a felony to 4th degree in violation of 2913.51. And counts 3 and 4, criminal damaging and endangering, each misdemeanors of the 2nd degree, and each in violation of 2909.06A1. I will at this time, as I indicated, finding the defendant eligible for intervention of conviction, grant your motion at this point. I'm going to order a stay of all further criminal proceedings. I'm going to place the defendant under the supervision of the Lake County Adult Probation Department for a period of 2 years. And I'm going to order the implementation of the following intervention plan. I'm going to order that the defendant serve 45 additional days in the Lake County Jail and order that he immediately enter and successfully complete the jail treatment program. So you're going to get some drug treatment program before you get out, because obviously there was an issue with using when you were out on your own. I'm also going to have him complete the decision points program, so he can start that while he's in, and I'll finish that most likely when he's out. It's a good program, just helps you make good decisions and think about what you're doing. The other conditions, then when you get out, you are to immediately get the Signature Health, get assessed, follow whatever recommendations are made for any type of mental health counseling. I also want a psychiatric assessment. In terms, they can look, determine what type of if any medications will be appropriate. Follow their recommendations. Not to use any drugs or alcohol, that includes no marijuana. You must submit random urine screens. They have to be negative. I want you to attend 2 AA meetings a week. Have a sponsor. Once you get out, you have to obtain employment, maintain employment, or education. If you want to go to some type of school, get some type of training, you can do that as well. But a full-time basis, once you get out and you get back on your feet, you're keeping yourself busy, working and going to school. All right?
Yes, Your Honor.
Pay court costs and supervision fees, pay restitution to the victim of count 4 in the amount of $256.31. You'd only have one doctor and one dentist that could prescribe you medication. If you have a specialist, a psychiatrist, for example, that's fine as well. But only those doctors that you tell probation about that you get prescriptions from can you get your prescriptions from. You can't get prescriptions from other doctors that they're not aware of. You understand that?
Yes, sir.
And you can only get them filled at one pharmacy, so you need to let them know what that pharmacy is. You need to sign whatever releases they need as well, so they can talk to counselors or doctors or whoever they need to talk to follow up so they can do their job, all right?
Yes, Your Honor.
I'm also going to place you on the mental health management program. That's just a program where you and I will get together once every month, once every 6 weeks or so. We'll sit right there. You'll sit in that chair. I'll sit right across from you. I'm not going to be up here. And we're just going to talk about what's going on. You're not in trouble when you come here. You're going to leave here. Unless you do something stupid while you're sitting there, but that's never happened. That happened once. It's just that's not going to happen. So it's very informal, and it's just literally you're going to sit and talk about what's going on in your life, how you're doing with the stuff that you're supposed to do. If you're having any issues, you bring them up. We can try to figure out something else maybe if you're having any difficulty with anything. It's very, very informal, and it's just, again, sitting, talking, and finding out how things are going on. So I know you'll come here and be nervous because it's natural, I guess, but you don't need to be. Nothing bad's going to happen. It's going to take the place of one of your reporting days, so it's not really going to be even an extra time that you have to come in, because you're going to have to report to your probation officer, and that will count. Your probation officer will be here that day. Okay. Your lawyer will be here that day, and that'll count as the reporting date. And it's just, again, very informal, just to see how things are going. And if you have issues, make sure you bring them up at that time. It's not a time to keep things to yourself. Or if you're having difficulty with doing some of the stuff that we're talking about, you bring it up. We talk about it. All right, we're going to do that too. That'll start, probably about 4 weeks after you get out, and you get. I want you to get this other stuff settled in terms of your counseling and what's going on there, so we can talk about that. So it's going to be a little bit before that starts. And I'm going to make a phone call about this medication, see if we can get you back on that here.
Okay.
You understand all the conditions of the plan?
Yes, Your Honor.
Any questions for me?
No, sir.
All right. Is there anything I'm missing here?
Nothing, Your Honor.
All right. I need to advise you, if you fail to comply with any of these conditions, a motion to terminate the intervention in lieu will be filed. If that happens, at that point, then I'm going to vacate the stay of proceedings. I'll find you guilty of these 4 charges, and we'll proceed to sentencing, or anything that I just advised you of that could happen up to 3 years in prison. You understand that?
Yes, Your Honor.
All right. Ms. Bell, anything else for the record?
Just that count 5 be dismissed, Your Honor.
Yeah, count 5 will be dismissed as well. Smith?
Not on behalf of Mr. Irwin.
All right, thank you. Good luck.
All rise.
We're here this afternoon in the state of Ohio versus Robert Verbatten. The defendant is present open court with his attorney, Mr. Watson. We are here on two different case numbers. With regards to 25 CR 1528, it is the state's understanding that the defendant will waive his right to be indicted by the grand jury and plead by way of information to count 1, possession of cocaine, a felony of the 5th degree with the attached forfeiture specification. We will then incorporate the pre-sentence report and drug and alcohol evaluations that were completed in 25 CR 052 and proceed to sentencing on both cases, Your Honor.
Thank you. Mr. Watson, does that sound accurate?
Thank you, Your Honor. May it please the court, that is my understanding of this afternoon's hearing. My client on the 1528 case is prepared to enter a change of plea by way of information on that case. First, he understands that by entering a change of plea by way of information, he'll be waiving his right to have this case presented to the Lake County Grand Jury. He also understands that he'll be waiving certain constitutional rights, and no threats or promises have been made in order for him to do so, Your Honor. And then, correct, Your Honor, he also agrees to have the pre-sentence report on the 052 case incorporated on the 1528 case and proceed to sentencing on both cases, Your Honor.
Thank you. Mr. Verbatten, were you able to hear what the prosecutor and your lawyer just had to say regarding what they believe your intentions are here at this time?
Yes, Your Honor.
They indicated to the court they believe it's your desire to, in 25 CR 1528, that's the new case, waive your right to have this case presented to a grand jury. And I'll explain what that means here in more detail. And to then go ahead and plead guilty to that charge, which I will also review with you to make sure you understand it. If the court accepts your plea, we would then incorporate the pre-sentence report that was done in the other case to this case, and we proceed straight to sentencing in both cases. Where there's no agreement between the parties regarding any recommendations, each side is free to recommend to the court whatever sentence they think is the right thing to do. Is that your understanding of the discussions that took place between your lawyer and the prosecutor and what you want to do today?
Yes, that's correct, Your Honor.
Well, before I can accept your plea, I need to make sure you understand everything we're doing here. I need to make sure you understand what it is you're charged with and pleading guilty to, the right you had that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine those issues, I'm going to ask you a series of questions. If at any point when I'm asking you these questions, if you're unsure, unclear of anything I'm asking you, if you need anything repeated or clarified, if you want a moment to talk with your lawyer so you could ask him questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right?
Yes, Your Honor.
Very well, then let's get started. How old are you, sir?
46.
Are you able to read and write the English language?
Yes, I am.
Do you have any difficulty with that, or difficulty understanding what you read in the English language?
No, I do not.
Are you a U.S. citizen?
Yes, I am.
Now, before you came into court here this afternoon, have you had any drugs or alcohol of any kind?
No, Your Honor.
What about in the last 48 hours?
No, Your Honor.
Not even prescribed medication, nothing?
No, I take blood pressure medication.
When did you last have that?
This morning.
Anything else?
It was blood pressure medication and what else did I have? It's basically for my heart. I'm not sure actually what it's called, but
Some type of heart medication?
yes, Your Honor.
Anything else?
No, Your Honor.
Do either of those two medications affect in any way your ability to understand or appreciate where you are, what's going on around you, or anything like that?
No, Your Honor.
Now, did you receive a copy of the information that was filed in this case?
Yes, Your Honor.
Had a chance to look that over?
Yes, I have, Your Honor.
Now, in that information, you're charged with one count. What's alleged here? What you'll be admitting to is on or about October 20th, 2025 in Willoughby Lake County, Ohio, that you did knowingly obtain, possess, or use cocaine or some compound mixture, preparation, or substance containing cocaine. The amount did not equal or exceed the bulk amount, which makes the offense possession of cocaine a felony of the 5th degree. I'm not sure why the indictment uses this language about bulk amount for cocaine. It's not a...
Does the actual language say does not equal or exceed 5 grams
Yeah.
in 292511?
Yeah, it's a specific amount. It doesn't deal with bulk amount. Not, this is the lowest level felony, so it doesn't affect anything, but the shell shouldn't come up this way. That's over there. For cocaine, it shouldn't come up that way. Yeah, it's the 5 grams, 10 grams, 20, whatever. Now, there's also in this charge what's called a forfeiture specification that alleges during the commission of the offense you possess or have an interest in property considered to be contraband or an instrumentality. Contraband is property that's illegal just by the nature of the property itself, like drugs. An instrumentality is some type of property that there may not be anything illegal about it, but it's being used or possessed in an illegal manner to facilitate a crime, and you can't possess it for that purpose. And here it's alleged there's the cocaine along with 2 debit cards. Whole purpose of this is that you forfeit any ownership interest you have in that property and allows the state to be able to dispose of it at the appropriate time. You understand that?
Yes, Your Honor.
Any questions about it?
No, Your Honor.
Well, then before I can accept your guilty plea, I need to make sure you understand all the rights you're giving up, and you first of all have a right to have this case presented to a grand jury. So the charge I just read to you is an information. That's a criminal charge brought by the prosecutor without the case having previously been reviewed or considered by a grand jury. Now, what a grand jury is, it's made up of a group of citizens here from Lake County that get together and they meet privately. They meet in secret for the purpose of evaluating evidence in cases to determine whether probable cause exists that someone committed a crime. Probable cause is defined as some evidence that would suggest the person probably committed a criminal offense. Everyone in the state of Ohio accused of a felony has the right to have a grand jury independently review the evidence in a case and make a decision without the government being involved in that decision whether someone should be charged or not. And you have that right as well. But you can give up that right if you desire and go forward in the charge brought by the prosecutor and the information. And your attorney has indicated he believes that's what you want to do. Is that correct?
Yes, sir.
Before I can go any further, I need to have you acknowledge that here in open court in writing, and I have in my possession at this time a one-page document called a waiver of indictment, which sets forth what I've just explained to you about the grand jury process, and that you want to give up that right. Before I can go any further, I need to make sure you understand what this document says, and that you sign it here in open court. Now, my understanding is that before I came out here, you had a chance to go over this document with your lawyer. Is that correct?
Yes, Your Honor.
Mr. Watson, is that accurate? Did you review this with Mr. Hervanton, go over it with him?
Yes, Your Honor. I did review the waiver of indictment form with my client. I read it to him. He read along with me, indicated he understood it, and then he signed it, and I signed it in the presence of the prosecutor, Your Honor.
Is that correct, Mr. Hervanton?
Yes, sir.
You understand what the document says?
Yes, I have.
You have any questions for me about it?
No, Your Honor.
Now, it does appear you signed it as your lawyer alluded to. Did you, in fact, sign it?
Yes, I did, Your Honor.
And you witnessed that too, Ms. Contour?
I did, Your Honor.
All right, that'll be made part of the record. At this point, I'm going to review with you all the other rights you have that you're given up by pleading guilty, and you first of all have a right to a trial. And a trial could be to me as a judge, where I listen to all the evidence and I make that ultimate decision whether you're guilty or not guilty. But you also have a constitutional right to have a jury trial. Jury trial would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. The jurors would consider and weigh all that evidence, and then the jurors would make that ultimate decision. And that ultimate decision reached by the jurors would have to be unanimous, which means all 12 jurors would have to agree together, one way or the other, whether you're guilty or not guilty. You understand that?
Yes, Your Honor.
You understand by pleading guilty you're giving up your right to have a jury trial?
Yes, I do, Your Honor.
Give me 1 second. Now, if we did have a trial, prosecutor here would be representing the state of Ohio, and she would have what we refer to as the burden of proof, with her having the burden of proof, what that actually means is that it is her job, or she bears the responsibilities, or the responsibility, the obligation of proving you guilty before you could ever be found guilty or presumed innocent of this charge, and that presumption of innocence sticks with you and remains with you until the state, if at all, was ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes, sir.
Now, when I speak of this burden of proof, since this is a criminal case, the burden of proof is what we refer to as proof beyond a reasonable doubt. It's the highest burden there is in our justice system. And what that actually means, it's the amount of the evidence and the quality of that evidence that the state would have to present in a trial to prove you guilty before you could ever be found guilty. Do you understand that?
Yes, sir.
Do you understand by pleading guilty or giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt at a trial?
Yes, I do, Your Honor.
Now, in order to try to do that, if we did have a trial, the prosecutor would present witnesses that come to court to testify for the state by answering questions from the prosecutor. Once those witnesses answered the prosecutor's questions, then your lawyer would have the right to ask those same person's questions on your behalf. That's called cross-examination. He could ask them anything he wanted to within certain rules. Do you understand that?
Yes, Your Honor.
You understand by pleading guilty or giving up your right to cross-examine or confront those witnesses that would come in here and testify against you?
Yes, I do, Your Honor.
Now, you'd also have the right at a trial. You'd call your own witnesses to come to court to testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that. You're not required to do that, but you have a right to do that if you wanted. Do you understand that?
Yes, I do, Your Honor.
And you further can request the court issue an order. We call that a subpoena. And what a subpoena would do, it would force or make someone come to court and testify for you and answer your lawyer's questions if they weren't willing to come in voluntarily on their own. You understand that?
Yes, I do, Your Honor.
You realize you're giving up that right?
Yes, I do, Your Honor.
Now, you'd also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That's a decision or a choice that you would have to make. Do you understand that?
Yes, I do, Your Honor.
And since that's your choice, what that really means then is that nobody else could force you or make you. Nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify. But more importantly, the prosecutor is not allowed to call you as a witness and make you get up on the stand and answer questions and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes, I do, Your Honor.
Further understand that if we did go to trial and you were found guilty, you would have the right to appeal or challenge that guilty finding. By pleading guilty here today, you're giving up or waiving any right you have to appeal a guilty finding. The court will enter if your plea is accepted, as well as any other issues you could have raised or brought to my attention up to this time. Do you understand that?
Yes, I do, Your Honor.
All right, well, do you have any questions at all about these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
No, Your Honor.
Do you understand them all?
Yes, I do, Your Honor.
Do you still want to plead guilty?
Yes, I do, Your Honor.
Do you understand a guilty plea is a complete admission of guilt? It means you're admitting to the facts being alleged by the prosecutor. We're not going to argue later that you didn't do it or it's someone else's fault or anything like that. Do you understand that?
Yes, I do, Your Honor.
Further, as a result of pleading guilty, the effect of that plea is that you'll be found guilty by the court, and then you will subsequently be sentenced by the court. Do you understand that?
Yes, I do, Your Honor.
Now, as far as sentencing goes, you're pleading guilty to a felony of the 5th degree. This is punishable by a possible term in prison of a minimum of 6 months, a maximum of 12 months, or any whole number in that range of 6 to 12. Do you understand that?
Yes, I do, Your Honor.
Now, I know you have this other case pending that we're going to be sentencing on. Do you have any other charges pending against you anywhere?
No, Your Honor.
Were you on probation anywhere when, or parole or any type of supervision when this offense occurred?
No, Your Honor.
In this case, as I mentioned, we're going to proceed to sentencing on not just this case, but the other case. So I need to advise you that if a prison term is imposed In each case, I had the discretion to run those prison terms either concurrent or consecutive. Concurrent means together at the same time. Consecutive means one after the other. You serve the prison term in the first case, whatever it is, finish it, then the prison term in the next case. You understand the difference there?
Yes, I do, Your Honor.
So with both of these cases, you're looking at a maximum prison term of 2 years in prison. You understand that?
Yes, I do, Your Honor.
Now, if a prison sentence is imposed upon your release from prison, you could be put on what's called post-release control. It's sometimes referred to as parole. It's a period of supervision you would be on after you serve the prison sentence. And with this case, again, it could be up to 2 years. You understand that?
Yes, I do, Your Honor.
And if you were put on post-release control and you were violated any of the conditions of your supervision, we would have a hearing to see if what's called a probation violator, I jumped ahead of myself. If you were put on post-release control and you're violating the conditions of your supervision, the parole authority would have a hearing to see if you, in fact, violated, and if they determined that you were, they could return you to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of the prison term imposed. I have no involvement in that proceeding. You understand all that?
Yes, I do, Your Honor.
All right. Now, aside from the possible prison sentence, there's other sanctions that could be ordered. You could be fined up to $2,500. You could be ordered to pay court costs. You could also be ordered to reimburse the county for any cost of confinement, community supervision, or treatment, if any of that were applicable. Do you understand that?
Yes, I do, Your Honor.
You can also suspend your driver's license for up to 5 years. Do you understand that?
Yes, Your Honor.
And lastly, as I earlier explained, any right, title, or interest you have in any of the property in that forfeiture specification will be forfeited to the state of Ohio. Do you understand that?
Yes, I do, Your Honor.
Now, a few moments ago, I explained the possible prison sentence. I used the word possible because prison is not mandatory with this charge. You are eligible for probation, or what we refer to as community control sanctions. Do you understand that?
Yes, I do, Your Honor.
Do you understand that just because you're eligible doesn't mean you'll automatically be put on probation? It means I will consider that, if that's what you're asking for. I'll look at all the information that gets presented, then I'll make the decision that I thought and think is the right thing to do. Do you understand that?
Yes, I do, Your Honor.
Now, if you are put on community control, it could be up to 5 years of supervision. As the judge, I have the discretion to order a wide variety of rules or conditions for you to follow. One of the conditions could be an order that you serve a term in the Lake County Jail of up to 6 months, the condition of probation. Do you understand that?
Yes, Your Honor.
Further, if you are on probation in this court at any point and never violate any of the conditions, we would have a hearing at that point then to see if you're what's called a probation violator. And if it was determined that you were, I could extend your probation up to 5 years. It wasn't originally 5 years. I could impose more restrictive sanctions against you, or I could terminate your probation and send you to prison at that point. And if I did it at that point, again, it could be 6 to 12 months, and that could be consecutive to any other prison sentence you may be serving or that you're being sentenced to at that time. You understand that?
Yes, I do, Your Honor.
Lastly, when we do proceed to the sentencing hearing, you'll have the right at that time to say anything you want, anything you'd like me to know or consider. Your lawyer can speak on your behalf. He can recommend the sentence to the court. The prosecutor can also recommend the sentence to the court. Do you understand that?
Yes, Your Honor.
Do you understand that whatever the lawyers say at sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation, and I don't have to follow that if I didn't think that was the right thing to do. You understand that?
Yes, I do, Your Honor.
All right, well, do you have any questions at all about the potential penalties you face by pleading guilty?
No, Your Honor.
You understand all the possible consequences?
Yes, I do,
You
Your
still
Honor.
want to plead guilty?
Yes, I do, Your Honor.
Have you had enough time to discuss this with Mr. Watson and have him go over everything with you and answer your questions?
Yes, I have, Your Honor.
Are you satisfied with his advice and counsel?
Yes, I am.
has he or anyone made any promises to you about what's going to happen at sentencing, which is inducing you to plead guilty today?
No, Your Honor.
Have you been threatened or coerced in any way to plead guilty?
No, Your Honor.
Are you entering the plea freely and voluntarily?
Yes, Your Honor.
All right, then, any questions for me at this time regarding anything we've just talked about?
Not at this time, Your Honor.
Do you need any more time to talk with your lawyer before we go forward with your plea?
No, I do not, Your Honor.
All right, then what's going to happen at this point, the prosecutor is going to explain for me what she believes the evidence would show if we had a trial. I want you to listen to her because I have some questions for you, all right?
Okay, Your Honor.
Ms. Cantor?
Thank you, Your Honor. On October 20th of 2025, the defendant did have a warrant out for his arrest based on his failure to appear in 25 CR 052. The Willoughby Police Department did arrest him at the Willoughby Target in Lake County. Upon searching his person, there was suspected drugs found in his pants pocket. Those were sent to the Lake County Crime Lab and confirmed to be cocaine, the amount being less than 5 grams.
Mr. Ravat, were you able to hear what the prosecutor just had to say regarding what she believes the evidence would show if we had a trial?
Yes, Your Honor.
What, if anything, do you have to say about those facts as she presented them? Are they true? Did you do as she said?
Yes, I did, Your Honor.
Very well. Regarding count 1, charging you with possession of cocaine, a felony of the 5th degree with the forfeiture specification, what is your plea to that count?
Guilty, Your Honor.
All right, I have in my possession at this time a 4-page document called a written plea of guilty and judgment entry, which explains everything I've just explained to you. Before I can accept your plea, I need to make sure you understand what this document says, and that you sign it here in open court. Now, my understanding is before I came out here, you had a chance to go over this with your lawyer. Is that correct?
Yes, Your Honor.
The only thing I added to this document where the medications reads is that you haven't used any drugs or alcohol in a 48-hour preceding this hearing except for blood pressure and heart medications. Otherwise, it's what you saw. Mr. Watson, did you go over this with your client, read it over with them, make sure you understood it?
Yes, Your Honor. I did review the written plea of guilty form with Mr. Havaden. I read it. He read along with me. He indicated he understood it, and then he signed it, and I signed it in the presence of the prosecutor.
Is that correct, Mr. Havaden?
Yes, it is, Your Honor.
You understand what the document says?
Yes, Your Honor.
You have any questions for me?
No, I do not, Your Honor.
It also appears you signed the document. Did you sign it?
Yes, I did, Your Honor.
And again, Mr. Watson, you witnessed that?
I did, Your Honor.
And you as well, Ms. Cantor?
I did, Your Honor.
Very well, then. At this time, the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in open court with his lawyer advised of all his constitutional rights and made a knowing, intelligent, voluntary waiver of those rights. The court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea. Find the defendant guilty of count 1, possession of cocaine, a felony of the 5th degree, in violation of Revised Code Section 292511 with the forfeiture specification. I will incorporate the pre-sentence report that was completed in 25 CR 052 into this case. And give me 1 second, let me look at one thing here. All right, Mr. Watson, with me incorporating the PSR into the other case, is there any reason not to go forward in sentencing in both of these cases?
No, Your Honor.
Is there anything you want to say on behalf of your client?
Thank you, Your Honor. May it please the court. Mr. Hervatin, I know this court's familiar with him. I know he's been in front of this court before. But Mr. Hervatin is a drug addict, Your Honor, and I know he isn't being very forthcoming to probation. When it comes to that, a lot of drug addicts are in denial, and that's my personal belief as to where he's at. But I've had numerous conversations with him ever since he got picked up, most recently for this new case. And he's told me that he's sick and tired of being sick and tired. And that, if you will, Your Honor, is a saying in sobriety circles. And, he's close to my age, and he's told me I'm getting too old for this, and I can't continue on getting high, using drugs, stealing, which a lot of these cases, I believe there was even a theft originally from the target, to support his drug habit, and he's fed up with himself. Your Honor, I know that there's little to no reason for the court to even consider this because he failed to show up on the first case, but just for the record, and so the court's aware, I did have the social worker at the Lake County Public Defender's Office, Aaron Mayer, reach out to Lake Geauga Recovery Centers. Mr. Hervatin is technically on their wait list for a bed. Mr. Hervatin has expressed to me, you'll hear from him in just a second, that he really wants to address his drug addiction issues. But again, I know he hasn't cooperated. He skipped out on his last case. I know he wasn't quite forthcoming. If the court doesn't feel that that's an appropriate sentence, I would respectfully ask the court to just consider the fact that on this new case, he pled by information. He's taken full responsibility for his actions. He's here hat in hand, Your Honor. I'm asking the court to consider on the lower end sentence for him. Let him do his time. Hopefully he'll use his time wisely so when he gets out, he's got at least hopefully a foot in the door of sobriety where he can continue on with. Mr. Hervatin expressed to me that he does have a good paying job, or had, and I believe he can go back to it at some point. But Your Honor, I would just ask the court to take all of that into consideration. Thank you, Your Honor.
Thank you, Mr. Hervatin. You have the right to address the court before you're sentenced. You can say anything you want. Is there anything you want to say?
Yes, fast in.
Do whatever you're comfortable doing.
Yeah, I mean, it's been on and off. Even when I got out of prison, I didn't think I could get a job or a good paying job, and I was wrong. I did 28 days out of prison. It's just when I panicked, I went back to the old me, and most of that situation was because of stable living, and I wasn't able to figure that out completely. So it wasn't like blaming the courts, blaming probation for, my sentences. It was my responsibility. They were trying to help me. I was there because of my actions, and I don't know if you have kids, but mine are done with me.
You're a what?
They're done with me until I prove it. And before it was like, 80% effort, 95. And
when were you ever making a 95% effort?
Even when I first got out of prison, I went to the homeless shelter. I reached out to Cleveland Food Bank, the social worker, to help me with employment. Went to Reserve Network. That's how I got my job, and I was doing right way. And then 6 months later is when I used again. But that's not good enough. It has to be all the way. And I can't lie. Like I said, my kids see through it, and lying to myself and everybody else. It'll never end. I mean, I learned the definition of dope. It's death or prison eventually. That's true for me 100%. And I've done the okay, I've done everything. And Lake House helped me a lot, and I should have reached out to them even when I panicked. But I panicked, and then it made it worse for myself and everybody around me instead of just asking for help. And I can't approach it that way anymore. I'm done. And I need your help to do that, because I put myself in a situation.
I've given you my help before, and it hasn't worked at all.
No,
I don't know. You were on probation before, and you violated at least 3 times before I finally sent you to prison. And they gave you every break in the world. And then you got, with the prison, you got out within 6 months, you pick up a new felony. And then you're on bond, don't show up, and you pick up another felony. Now what's interesting is that you say when this new case happened, you weren't even using it at that time.
I went to Ethan's Crossing a week before, and I got out 2 days before that to detox, because I wanted to get clean.
So when you say you weren't using it at that time, you're talking about like that day, that within a few days. You're not talking a long period of time.
Within about a little over a week, because I went to Ethan's.
So you were using a week before.
That's why I went to Ethan's Crossing. I went on, I think, on a Sunday, the Sunday before, and then I got out either Friday or Saturday of the week after.
Anything else you want to say?
I mean, I understand I probably don't deserve a chance, but I will take it seriously. I will. I mean, I probably don't deserve it, but I am asking for your help.
Thank you. Mr. Watson, anything else?
Nothing further, Your Honor.
One second, please. So in the PSR, you said you began using cocaine in your 20s. Your use became weekly around 2020, start and stop. You did not use it when you were in prison. And then you said you began using cocaine again in September of 25, twice a week.
Yeah, the time frame sounds about right, yes.
What were you using before that?
Before September?
Yeah.
Nothing, Your Honor.
Then why didn't you come to court in June? Why didn't you come to court in July and August? You're supposed to be here in June and you didn't show up. You weren't using at that time. Why didn't you show up if you weren't using?
I panicked because I had a misdemeanor warrant through Willoughby Court for not appearing.
Why didn't you appear in your Willoughby Municipal Court case?
Because I was using it at that time.
Sir, that was just April of this year. You
Yes.
said you weren't using anything.
No, I wasn't using. It was like sporadically, and
Sir, you were using in April, then you weren't using in June, and you
Yes.
started using again in September.
yes, Your Honor.
Mr. Watson, anything else?
Nothing further, Your Honor.
Ms. Contour?
Thank you, Your Honor. The state is recommending prison in both of these cases. As discussed, the defendant was on bond conditions. There was a warrant out for his arrest based on failing to appear in June for his change of plea hearing on the case ending in 052. That's why he was arrested in the new case and searched, resulting in the new charges. He also has prior prison term and was offered the opportunity for NeoCap and other treatments within the last several years. So the state does not feel that he's amenable to community control sanctions and would recommend a term of prison.
Court reviewed the pre-sentence report and investigation. I've considered the facts and circumstances of both offenses, the nature of each offenses. I've considered everything that's been said here in court today by Mr. Watson, the defendant himself, the prosecutor. The recommendations, all this is considered in light of the purposes and principles of felony sentencing set forth in 29-29-11. For the factors in 29-29-12, nothing in either case makes it more or less serious. As for recidivism factors, almost all of these are present. Case 25 CR 1528, the defendant was on bond, and 25 CR 52 at the time he committed the offense. He's got an extensive record. I mean, ever since the offense that you were on probation to me last time, which occurred in July of 19, you were sentenced and put on probation in April of 20, you've committed 7 more offenses. And you were in prison for a portion of that time. He has not complied with previously imposed sanctions ordered by courts. He has been on probation to me before in the past, and he got violated multiple times. I just gave him chance after chance after chance. I mean, we were at least 3 probation violations the last time he was with me. There's obviously a drug abuse problem that relates to the offense, and he does not acknowledge the extent of this problem. Both cases that are before me, he's claiming in the first case the drugs weren't even his. In the second case, he forgot the drugs were there, didn't know they were there. He minimizes his use, the extent of the use, and the seriousness of his use. No genuine remorse in regards to the offense. No factors indicate recidivism is less likely. Under 29-29-13B1, defendant previously served a prison term. In case 25 CR 1528, he was on bond to the court. Prison is consistent with the purposes and principles of sentencing, and there's no way this court can make any finding that the defendant was amenable. I did forget in the recidivism factors that the defendant violated his bond in 052 by failing to appear in court and a warrant having to be issued for him and him being arrested to be able to get back in court. And when he gets arrested, he's got more drugs on him. But he's demonstrated that he's not amenable with all the prior probation violations, all the offenses that have occurred within the last few years, his failure to even comply with conditions of bond, in this case, and appear in court. And prior, apparently, a failure to appear in other courts. Prison is consistent. Therefore, it will be the sentence of this court that in 25 CR 052, defendant served a term in prison of 8 months. He has credit for 69 days he's served. Case 25 CR 1528 is the sentence of the court. Defendant served a term in prison of 9 months. Those 2 sentences will be served consecutive to each other for a prison term of 17 months. There's no credit on the second case since all of that was given in the first case. Need to advise you in both cases upon your release, you may be put on post-release control for up to 2 years. If you are and you violate any of those conditions, the parole authority can return you to prison as punishment for violating the rules for another 8.5 months, the maximum being 50% of the term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. The court disapproves the defendant's placement in a program of shock incarceration and intensive prison program or transfer to transitional control. The court will order the forfeiture of the contraband and instrumentalities in each case. bond was previously forfeited in 25052, so that's not going to be released. So don't include that language in that entry. No bond was ever posted in the other case. Court finds that consecutive service is necessary to protect the public from future crime or to punish the offender, that they're not disproportionate to the seriousness of his conduct, and to the danger he poses to the public, and that he committed the offense in 25 CR 1528 when he was on bond to this court in 25 CR 052. That covers everything. Ms. Contour, is there anything I omitted or need to address?
Your Honor, the only thing I did not hear you state is anything about costs and fees for either case.
Well, no fees, but he has to pay court costs. And I'm not going to impose any fine or license suspension. It's just
Thank you.
costs. Schwatson?
Nothing further, Your Honor.
Thank you.
All right.
Thank you, Your Honor. We're here today in the state of Ohio versus Erica Mosley, case number 25CR601. The defendant is present with counsel Dennis LeConte, and we're here today for a sentencing hearing. We were last before you on November 7th for a change of plea hearing. At that time, the defendant pled guilty to count 1, receiving stolen property, a felony in 5th degree, count 2, theft, a misdemeanor of the 1st degree, and count 6, identity fraud, a felony of the 5th degree. During that hearing, a pre-sentence report and victim impact statement were ordered. That report has been completed, and the defendant has 76 days of jail time credit.
Mr. LeConte, any reason not to go forward with sentencing?
No, Your Honor, there is not.
Anything you'd like to say on behalf of your client?
Yes, Your Honor. Ms. Mosley has been incarcerated for a fairly significant number of days. She is very remorseful about her conduct, and the circumstances have basically separated her from her young child. The child's being cared for by kind of a family member, but she's really desperate to get back to her child and wants to do that. As the court's aware, there is this case that's been pending in Cuyahoga County. She has not been able to attend to that because she's been incarcerated here, and she desperately wants to be able to get to Cuyahoga County to deal with that case. She's still on bond there. They never revoked her bond. And so I think it's, obviously the charges there are serious, but she hasn't been convicted of anything. And so I think it's important for her to get there to deal with that. I would ask the court to consider giving her a community control sanction in light of the days that she's already done here. She's willing to wear an ankle monitor if the court would want that, and that would allow her to go deal with her case in Cuyahoga County and see what happens down there. If at some point she got convicted of something down there, certainly I think the court could then change its mind, because that would technically be a probation violation, community control violation. The court could deal with her differently at that point, but at least it would allow her to go down there and deal with that without having to go to prison first, and it would allow her to get back with her child, which she desperately wants to do.
Thank you, sir. Ms. Mosley, you have the right to address this court before your sentence. You can say anything you want. Is there anything you want to say at this time?
Yes. I feel like my lawyer.
Sorry?
I feel like my lawyer basically said the same thing that I want to say. I do apologize. I do want to be out to be able to fight the case. And I'm hoping that I can at least get on probation so I can go home to my kid and fight my case. I do want to apologize to the victim. That was a foolish thing to do. That's really it. Thank you.
Thank you. Mr. LeConte, anything else on behalf of the defense?
No, Your Honor, although I would tell the court that Ms. Mosley has not run from any of the places that have had a case. She posted the bond in Cuyahoga County. She did not run from this court, and in fact, the only reason this court, if you recall, revoked the bond was because she was locked up downtown. And then she went out to Erie and took care of everything out there. So despite doing some things wrong, which she's acknowledged, she does take steps to fix things the best that she's able to do. And so I think she's a fair risk for a community control sanction at this time.
Thank you. 1 second, please. Bell for the State of Ohio.
Thank you, Your Honor. The state had the opportunity to review the pre-sentence report in this case, and it has some concerns here. The defendant does have a prior criminal history, which includes theft offenses, telecommunications fraud, identity fraud, and drug possession. 6 out of her 10 adult cases are about theft as a theft offense, based on my count. She was on probation when she committed this offense, and then, as we already discussed briefly, she picked up a case when she was on bond in this case in Cuyahoga County. She also has a history of probation violations. So the state would recommend prison in this case. Cannot say that she's a good candidate for community control. And the state would also ask for a restitution order in the amount of $150 to the victim, Ashley Rockwell.
I got a victim impact statement saying $200. She said there was a gift card also that was taken.
I have no reason to doubt her. That's just what my notes say.
Okay, fair enough. This court has reviewed the pre-sentence report investigation, the victim impact statement. I've considered the facts and circumstances of this offense, the nature of this offense. I've considered what everybody's said here today. Shulakanti, the defendant, the prosecutor, the recommendations. All this is considered by the court in light of the purposes and principles of felony sentencing set forth in 29-29-11. For the factors in 29-29-12, court finds the defendant acted as a part of organized criminal activity in committing this offense. Nothing makes it less serious. As for recidivism factors, court finds there's a history of criminal convictions that go back 10 years as a juvenile. Then as an adult, goes back to 8.5 years ago, which is right when she became an adult. The history of theft-related offenses, same thing that brought us here today. Drug possession, theft. Theft. Seeing stolen property. She was on probation to the Berea Municipal Court when she committed this offense for a theft charge. She was on bond to the Erie County, Pennsylvania when she committed this offense. She was on bond to the Niles Municipal Court when she committed this offense. And then none of that stops her. Just continues doing this same type of conduct. You talk about wanting to be home with your daughter and your kids and all that, but you're not engaging in conduct that's consistent with that. You want me to feel bad. You want me to do something about that, but you're not doing anything about that. You're not doing anything. You know what you're doing is wrong. You know what you're doing. If you get caught, you're going to be in jail. You're going to go away. And you're doing it anyway. Over and over and over. With charges pending against you. You continue doing it. What you're saying doesn't come across genuine. You've been arrested on a new charge. Now, it's a new charge. I'm not considering it as any conviction or anything like that, but nonetheless, there's new charges pending against you, serious new charges, which are alleged to have been committed while these were pending. Those are all factors indicating recidivism is more likely. There's nothing that makes it less likely. 29-13B1, the court notes defendant again committed the offense while on probation as well as on bond. Prison is consistent with the purposes and principles of sentencing, and I don't see how I can make a finding defendant's amenable to community control sanctions. Therefore, it will be the sentence of this court that on count 1 and 6, defendant serve a term in prison of 8 months. I'll run those concurrent with each other. Count 2, the misdemeanor charge shall be sentenced to serve 120 days in jail. Those are all concurrent. So for a total of 8 months in prison. She has credit for 76 days she's already served. I'm going to restitution be made to the victim in the amount of $200. Need to advise you upon your release, you may be put on post-release control for up to 2 years. If you are and you're violating any of those conditions, the parole authority can send you back to prison. It's punishment for violating the rules for another 4 months, the maximum being 50% of what I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. Court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, or transfer to transitional control. Defendant's awarded the penal costs. I'll dismiss the balance of the indictment. Bell, is there anything else that I need to address?
Nothing further, Your Honor. Thank you.
Your Honor, how many days are you showing that?
Credit? For credit?
Yeah.
I got that from the PSR, didn't I? Is that where we got that time?
Yes, Your Honor. 76 days.
76. Anything else?
No, Your Honor.
Ms. Mosley, when you go down there, you can send that notice of availability. It'll be applicable at this point, so you can get brought back and start dealing with that other matters as well.
To Cuyahoga?
Sorry?
To Cuyahoga?
Yeah. All right, thank you.